join as they enter. But first, I just want to start by thanking all of you for joining today's webinar. My name is Trevon Mears. I'm the Director of Policy and Community Outreach here at the LGBT Center in New York City. Today's webinar is part of a series that we are calling RiseOut Synergy Sessions, where the goal is to really engage community members and allies across the state to hear about relevant advocacy opportunities and to get a broader understanding of what it takes to mobilize around LGBTQ civil rights statewide. So for this webinar, we wanted to unpack the gay trans panic defense, which is understandably a complex issue. We thought it was important to take a look at some of the historical context of where the defense came from, how it has been applied across the country, and some of the current efforts in New York State around banning it. So hopefully today's presentation gives you all a more complete understanding of the law. Before we start today's webinar, there are a few processes to keep in mind. First, everyone has been muted so as not to distract the presenter and the other participants while the webinar is taking place. We're also recording the webinar, so to make sure that things are moving smoothly, there will be a few pauses during the presentation where we will respond to written questions. So if you think of a question, please use the chat function at the bottom of your screen to type it and share it with us. We hope to take a few questions from the chat throughout the presentation and again at the very end. Today's webinar will be presented by Milo Primeaux. Milo is a queer trans civil rights attorney, professional consultant, public speaker, and the founder and CEO of Just Roots Consulting LLC. He has fiercely advocated for the rights of LGBTQ plus communities across the country for more than 15 years, and that has included everything from grassroots organizing to overhauling corporate personnel policies and spearheading high-level statewide policy reform. So we're thrilled that Milo is able to join us today, and with that, I will now turn it over to Milo.
Awesome, thank you so much. I'm happy to be back here with you all today. Okay, so we have a lot of ground to cover, and I don't want to spend too much time at the outset, but I do want to provide my contact info at the beginning in case you do have any follow-up questions or concerns that we don't get to during the webinar today. With the flow of the webinar, it didn't make sense to put this at the end, you'll see. So I just wanted to throw it out there at the beginning in case you want to copy down or take a screenshot. But essentially, you know, when we're talking about this very big and important topic, there are a lot of pieces to it that that make it a little bit outside of a lot of people's areas of expertise or understanding. It can be a little confusing and complicated, but you know, we want to take this opportunity to just clarify a few things, demystify it, make it graspable, and also make it so that you feel comfortable taking next steps moving forward with these efforts if you feel compelled to do so. So today, we are going to answer these questions. By the end of the webinar, you should know what the gay trans panic defense is. You should know how it's being used to harm the community, what is happening in New York to stop it, and how our efforts in New York are comparing to other states across the country, and what you can do to get involved and to help. And before we jump into the nitty-gritty of it, I just want to take this opportunity to share a lamb from my farm who's newborn to symbolize the need for self-care throughout this webinar. I recognize at the outset that the things we're about to talk about are really difficult. We will be talking about violence against our community, and specifically against people because of their sexual orientation and gender identity and trans status, and the ways that people use homophobia and transphobia to hurt our community. So I just want to say that if you need to take any time during this presentation for self-care, if you need to step away from it or mute for a little while, that's totally fine. You got to do what you got to do. And I will try to let you know when the content is about to get heavy so that you can prepare yourself if needed. So, all right, with that being said, let's jump in. So first and foremost, why are we even talking about this? Well, despite all the progress that we have made socially and politically, LGBTQ people are still very much under attack. Crimes against our communities continue to rise every year, and they disproportionately impact trans and gender nonconforming folks and queer folks of color. Of course, it is now against federal and New York state law to violently attack someone because they are LGBTQ or the person thinks that they're LGBTQ. Our hate crimes laws add on more punishment for attackers who are biased in their hearts and minds against queer folks. And yet, there's a funny little loophole that is still open in the New York law and in most other states across the country that allow criminal defendants, people who are on trial for crimes, to use their homophobia and transphobia to their advantage to try to get off the hook or to reduce their sentencing. And that is what we're going to explore here today. So before we jump into the gay or trans panic defense itself, I think it's really helpful to have a little background about how it works within our New York State criminal legal system. So first, let's look at the criminal charges where it might come up to begin with. So for the purposes of this presentation, we're going to be talking mostly about these three charges only. All three involve an intent to kill and they differ based on who actually dies and how depraved or cruel the act was. So let's look at them really quickly. So second-degree murder is sort of the lowest end of the spectrum of severity. In order for somebody to be convicted of second-degree murder, they have to be found that there was an intent to kill somebody, that they actually killed someone, whether it was the person they meant to kill or somebody else. And if it's driven by hate, it can result in more punishment. So our hate crimes law in New York applies to second-degree murder only of these three. And in addition to a whole bunch of other things like stalking and assaults and other things like that. But when it comes to murder, the hate crimes law only applies to second-degree murder. The next kind of step up from that is aggravated murder, which again also involves an intent to kill. And then the person who actually dies is someone who's performing official duties at the time, like somebody who's an officer of police, parole, probation, even a firefighter, that sort of thing. Or it involves a child who was under the age of 14. So this is intentional murder, but it's a little bit worse than second-degree murder as far as it being sort of egregious goes. And then the top sort of worst version of murder is first-degree murder, where there's an intent to kill, someone actually dies, and there's one of over a dozen other criteria met that sort of elevate the severity of the crime to make it even more depraved or heinous or cruel. There's a whole bunch of them. So the reason we're looking at all three of these is that they all include an intent to kill. And for all three of these, there's a certain affirmative defense that is available to a defendant who's trying to defend themselves in a criminal case when they're on trial for these. And that's what we're going to look at next. So an affirmative defense is something that once a defendant has been shown to be guilty of something beyond a reasonable doubt, they would try to say that they had a good reason or excuse for killing the victim, and then that is enough to mitigate or reduce their punishment. So this is an affirmative defense. It's a yes and defense. So three very common affirmative defenses that you might be familiar with are self-defense. So you protect yourself when someone attacks you. Mental illness, you can't be held fully responsible for what you did because you were mentally ill at the time it happened. Or this is the one we're going to focus on, heat of passion or extreme emotional disturbance. This is where you are blinded by such passionate rage that you lose all sense of control over what you do. So while other states may call it by another name like heat of passion, New York recognizes the extreme emotional disturbance as an affirmative defense that's available for the crimes of second-degree murder, aggravated murder, and first-degree murder. With this, what we're talking about is that someone is provoked so much, something is so provocative and outrageous that it causes a defendant to experience what's called sort of a significant mental trauma that doesn't quite rise to the level of insanity. It doesn't mean that they're insane or not mentally well, but it does make them less responsible for their actions. This thing is supposed to be so excessive and violent a disturbance that it causes this mental trauma. This is classically portrayed in movies where a person comes home to find that their spouse is having sex with someone else, and then they, kill one or both of them in an envious blind rage, right? A lot of Law and Order SVU episodes about that, a lot of movies about that. That's what we kind of think of as extreme emotional disturbance. In New York, this is a defense, again, to second-degree murder, aggravated murder, and murder in the first degree. So in all of those, there is an intention to kill somebody, but if a person can show that there was a good enough reason that that rises to the level of an extreme emotional disturbance, their conviction might get knocked down to manslaughter, and their punishment might be much shorter. So how does this relate to the gay and trans panic defense? Well, sometimes the extreme emotional disturbance defense is used in a way that plays off of the social stigmas about LGBTQ people, homophobia and transphobia, in a way that tries to excuse the act of murder. So in this twisted work of logic, unwanted same-sex sexual advances or not immediately disclosing one's gay or trans status could be considered, quote unquote, excessive and violent conduct that causes, quote unquote, significant mental trauma. So this is what we're talking about when we're talking about a gay panic or trans panic defense. So for example, a defendant using this defense might say, yes, I killed her after I realized she was trans, but she provoked me by hiding her real sex from me. You would have done the same. Or I killed him, but only because I thought he was coming on to me and I lost all self-control. I couldn't help myself. When trying to prove this affirmative defense, the defendant has to show some kind of convincing evidence that makes these actions seem reasonable and understandable under the circumstances. And the emphasis is on the quality of the proof rather than the quantity. So even though there may not be a lot of evidence to show that what they're saying is true, there has to be something that would show some sort of reasonableness that a jury would agree with. Of course, that means though that the quality of proof is totally subjective and will be weighed differently by different jurors or judges on a case-by-case basis, which I'm sure you can imagine could be a problem. So before we move forward from here, does anybody have questions about the three different charges that we're talking about, the second-degree murder, aggravated murder, first-degree murder? What are the affirmative defenses, or how the gay trans panic defense is sort of used as an affirmative defense? We're going to look at some concrete examples in just a second, but I wanted to pause here in case there's questions.
Just a reminder that if anyone has any questions during the presentation, please use the chat function on your screen to write them. We haven't gotten any questions just yet, but I just wanted to throw that out there as a reminder to folks.
Okay, great. All right, so we'll keep moving, and if we get questions, no big deal at all. So we're going to take another quick land break. Oh, Trevon, were you about to say something?
Nope.
Nope, okay. So we're going to take another quick land break for a self-care check-in. So I'm about to provide some specific case examples of anti-gay and anti-trans violence to illustrate how defendants actually try to use the gay trans panic defense. I don't plan to go into a lot of detail about the violence, but there is some detail. So if you would rather not listen to this portion, feel free to mute now and unmute again when you see the scales of justice on your screen. that means that we're done talking about the examples and we're going to get to the rest of the presentation. Okay, so that being said, let's go on. So there are a number of examples across the country where the sort of defense has been raised in various forms. And I just wanted to highlight a couple of some of the classic examples and how it plays out. So the first one is with regards to Gwen. So Gwen in 2002 is a trans Latinx woman who's just a teenager. She was 17 years old. And she was savagely beaten and murdered by a group of men after they discovered that she was trans. After an initial trial, so there was a trial where 4 of the men were supposed to be on trial. The jury kind of came up with an indecision. They weren't really able to say for sure what happened and how people should be convicted. So it was declared a mistrial and they tried it again. And this time around, one of the men pled guilty to a lower sentence and was willing to testify on behalf or against the other men. And 2 of the other men were found guilty of second-degree murder. But the jury did not enhance their sentences with the hate crimes legislation that was actually available at the time. They did not think that it was necessary to do so. Shortly thereafter, just a couple of years after this trial happened, or actually the next year after the trial happened, the Gwen Araujo Justice for Victims Act became law in California. What it requires is that the courts instruct juries not to let bias, sympathy, prejudice, or public opinion influence their decision. And bias can include a person's gender identity or sexual orientation. So it specifically allows judges to give jury instructions around trying to eliminate bias in the courtroom and not let a trans person or a gay person's identity unjustly influence the jury's decisions and opinions about what's going on. It also encouraged the district attorney's offices, so these are the prosecutors in the state, to create resources and training to explain how panic strategies are used to bias jurors and how they play on societal bias in an unfair way, and to provide best practices for preventing them. This was all assuming that district attorney's offices had the funding to produce such resources and training, which I'm not sure if they did, but it was an attempt to try to address it in some way, an attempt that was strengthened later, and we'll look at what California did in just a few moments. So let's look at a couple of other cases where it worked and didn't work. So one case that where the defendant used this in a way that worked was in the case of Joseph Biederman. So in 2009, Joseph Biederman was acquitted of or let off the hook for first-degree murder for stabbing his neighbor, Terrence Hauser, 61 times in Chicago. Biederman claimed he killed Hauser in self-defense after he fell asleep at Hauser's house and then rejected his neighbor's violent demands for sex at sword point. Biederman didn't really have any evidence to support his affirmative defense. There was not really any signs of a heated struggle, and Biederman actually went home blood-soaked, took a shower, and went to the hospital before ever calling 911. So it didn't seem like it was really a sort of a heat of the moment thing, but something that might have involved something else. Nevertheless, the jury acquitted him of first-degree murder, and because the district attorney did not offer any other alternative charges, was very steadfast on getting first-degree murder or nothing, he was actually set free. So that is a case where it worked and the jury believed him. A case where it didn't work involves Mickey Cass, which is actually pictured here in this presentation. In 2003, Mickey strangled his roommate Victor after Victor grabbed his genitals and made other sexual advances during an argument, allegedly. There are no witnesses. Mickey stated that he just lost it. He snapped. He couldn't help himself. He strangled his roommate to death. During trial, he claimed that he had an extreme emotional disturbance due to mental illness caused by protracted sexual abuse as a child, and that Victor's advances triggered that abuse, and made him kind of lose his mind temporarily and do this act. However, when he did that, it allowed the prosecutor to actually bring up evidence of another time that Mickey Cass strangled somebody under very strikingly similar circumstances where it seemed like there was a same-sex sexual advance that occurred, and Mickey strangled that person as well. So because of this, the jury rejected Mickey's affirmative defense, and he was convicted of second-degree murder. And this was in Illinois. Another case involves Elan Nettles, which is close to home. So this is in New York City. In 2013, Elan, who was age 21 at the time, was severely beaten on the streets of Harlem by a group of men after they learned that she was trans. And she died a few days later due to her injuries. It took a while for the police to really investigate and find the person who did this, but when they did, they arrested and charged James Dixon with her murder. During the investigation, James said that he didn't want to be fooled by Elan being trans and that he had gone into a blind fury, essentially claiming an extreme emotional disturbance as the reason he did it. Before the case could go to a full trial, Dixon pleaded guilty of manslaughter in order to get a shorter prison sentence, I believe about 12 years, so much shorter than had he been found guilty of murder. But it was clear based on what he told the police that had it gone to trial, James was prepared to make an extreme emotional disturbance defense to try to get his sentence reduced to just manslaughter and his punishment reduced as well. And based on the state of the law in New York, that sort of defense would have been allowed, at least on a case-by-case basis, unless we do something legislatively to change that. So, so any questions here before we move forward? Any questions or comments?
No questions have come in the chat just yet. But again, taking a moment to encourage folks to write them down if you have any.
Great, thank you. All right, so now we are in, now we're in the portion where hopefully folks who may have needed to mute for self-care have rejoined us. So, you know, why should we ban the gay trans panic defense? Now we know what it is, we know how it's used. Why is it necessary for us to actually take action to stop it? So in case it's not obvious, there are several reasons why banning the gay trans panic defense would be important for our community, both literally and symbolically. So the first consideration is that the gay trans panic defense plays into harmful and false stereotypes and stigmas about our community. It really pushes into that idea, that very old and false idea about gay and trans people being predatory, dangerous, and deceptive just because of our sexual orientation and our gender identity and expression. And to allow that sort of defense to continue is to perpetuate those stigmas and stereotypes that we know are not true in a way that's really harmful to our community as a whole. Further, the gay and trans panic defense is antithetical or directly opposed to our state's policies supporting LGBTQ people in so many other ways. And this is across the board. We are recognized in the human rights law. We recently, got GENDA, which of course adds gender identity and expression to the human rights law specifically. We also have hate crimes legislation that specifically increases sentencing for people who commit hate crimes against our community. So as illustrated by this scale of justice that I have here, there's sort of a direct opposition of what's happening. On the one end, we see that if somebody commits murder against a member of our community, there's a possibility that their punishment will be increased due to the hate crime because the state has a very sound policy in discouraging people from harming one another based on bias and hate, and specifically homophobia and transphobia. So we punish people more when they attack members of our community. And on the other side, as long as this sort of defense is allowed, there's actually an opportunity for a defendant to be punished less for the very same reason. To say, well, you know, it was out of, I did kill this person, and it was out of homophobia or transphobia, but it's acceptable because that sort of thing is really scary, right? Which is not true, but also it stands in opposition to what the state has already made clear it believes. So it's in direct opposition to the rest of the policies of the state. And then even though it only comes up rarely, you know, it's not a super common thing to come up, especially in New York, although it comes up in other states with some more frequency. The very fact that the gay and trans panic defense could ever be raised in New York means that our state and our legal system are complicit in the violence that's being perpetrated against our community. Because by allowing it to even be a possibility, that the door is even still open, it means that our state agrees that it may be reasonable under certain circumstances that members of our community are killed. And that sort of reasoning should never be allowed to continue. And then finally, you know, trying to stop defendants from using the gay trans panic defense on a case-by-case basis, it's not enough. Juries can still be biased by homophobic and transphobic testimony and evidence that's raised during trial, and that can lead to hung juries, mistrials, and reduced convictions for violent offenders. So even though judges can try to nip it in the bud, it puts a lot of pressure on the individual judges to recognize what's going on and to be able to stop it before juries get to hear some evidence that will sway them in a way that's unfair and unjust towards our community, which is not always possible. So that being said, though, I do want to take a moment to address sort of the flip side of this coin, which is for folks who, you know, are advocates for people who experience over-policing and over-criminalization by our legal system and our criminal justice system, who might say, look, you know, shouldn't criminal defendants have the right to defend themselves however they need against a prejudicial state, a state that has, you know, there's clear and historical evidence of injustices inherent in the criminal justice system that target certain people. So why would we want to take away an option for a defendant to try to defend themselves? So to you, I'd say this, you know, it is true that the criminal justice system is flawed at every level. Absolutely true. People of color, poor people, and LGBTQ people are disproportionately impacted by police profiling and harassment, jury and judicial bias, arbitrary and mandatory minimum sentencing, and over-incarceration. And I agree, it is critically important for criminal defendants to have enough tools to defend themselves against an unfair system that is usually stacked against them. In New York, it's really important to note that there are as many as 25 affirmative defenses throughout our criminal code, in addition to other defenses that a defendant can call upon to fight against the state. So this is certainly not the only defense available, and there's quite a few others. That being said, though, you know, in my opinion, a defense that hinges on a common belief and understanding that it is ever reasonable to kill someone because of their LGBTQ status is absolutely unacceptable. That it's a false reason, it's a false defense. It's not based in a reality that's true, and it doesn't do anyone any favors to put it forward. By letting defendants continue to use this line of defense to excuse violent acts, New York State is effectively sanctioning hate crimes and discrimination against our community, and we have to put an end to that practice. So what's being done to tackle this? Let's take a look. So the basic timeline, it does go back further. People have been working on this for a very long time, but the most recent series of events are what we're going to focus on here. So in 2013, the American Bar Association called for an official ban of the gay trans panic defense nationwide. It passed a resolution saying that it should not be upheld and that action should be taken so that people can't make this defense anymore. In 2014, California took the extra step beyond that one law that we talked about earlier from 2006, and it actually banned the gay trans panic defense in cases that involve voluntary manslaughter, which is a little different from the charges of murder that we were talking about in New York. So every state classifies its homicides, the death of people, in different ways. And for California, their ban on these defenses specifically have to do with what they define as voluntary manslaughter. So being mindful of that. In 2016, Williams Institute at the UCLA Law School, which is an incredible think tank and research center for a variety of policy issues that impact LGBTQ people, published reports of how these cases are sort of panning out in different states across the country and what the legal challenges to them might be. And they also published model bill language that other states could use as a model to try to ban this sort of defense in their state. In 2017, Illinois actually moved to ban its panic defense using the model language from the Williams Institute, but the final version of Illinois' law actually only includes sexual orientation. The original bill included sex and did not include gender identity and gender expression specifically, but did include sex. And that language was dropped during the amendment process so that the final law in Illinois actually only touches on sexual orientation. So this may not surprise folks who have been in this work for a while and know what it's like to have protections for trans and gender nonconforming people dropped to get sexual orientation passed. So it just seems like another example of that happening. In 2018, Rhode Island took steps to ban the gay trans panic defense in all aspects, and it follows the model that the Williams Institute put out exactly to the T, so it's very thorough. There was also some federal legislation that was introduced to ban it in federal crimes. And then New York, there are now 2 bills that have been introduced that would seek to ban the gay trans panic defense in some way or another here in New York. And it's notable to say that at least one of those bills has been introduced for several years. But the reason it's sort of come to the forefront and the reason we're even doing this webinar is that because it gained a lot of traction during the last midterm election. It was a talking piece as part of the election platform. And so it's something that we've highlighted as a community that we want to pay attention to. The advocates who are working around this issue want to keep New York as a leader in this work and want to make sure that we stay in front of the ball on this. And so we currently have 2 bills that we're looking at in New York, and we're actually going to parse those out next. So what do these bills say? So looking at this chart, I'm going to tell you exactly what we're looking at. So at the top, you see that we have 2 bills. One is called New York, and it's Assembly Bill. That's what the A stands for, 02707. So if you Google it, you can pull up the full language of the bill. This was proposed by Assembly Person Danny O'Donnell. We have a second bill, New York Assembly Bill 02400, which was proposed by Assembly Person Brian Barnwell. So we have 2 different bills that are essentially seeking to do the same thing, but in slightly different ways. So both bills will work to restrict the use of this defense in terms of provocation. So specifically talking about extreme emotional disturbance. So both of them do that. They both apply to second-degree murder. So those are the cases, if you'll remember, where somebody has the intent to kill and someone dies. And also, if it's a hate-driven crime, there could be enhanced sentencing and punishment because of our hate crimes law. So second-degree murder is the one where this is most likely and commonly to come up in the course of things. And both of the bills cover second-degree murder. Notably, Only one of the bills also covers situations where somebody is being tried for aggravated murder or first-degree murder, and that is the second of the two bills there. So because extreme emotional disturbance is an affirmative defense that is available for all three of those charges, that one bill addresses all three of those charges as well, so that nobody would be able to use a gay or trans panic defense if they were being tried for any three of those charges of murder. The other one only focuses on second-degree murder with the idea that that is the one that's most likely to come up at any given time. Both of the bills will cover sexual orientation. So if somebody says that they were provoked into a blind rage and fury by someone's same-sex sexual advances, or discovering that someone is gay or lesbian or bi or whatever, that would be something that they would not be able to use as an affirmative defense because it has to do with sexual orientation. And both bills cover gender identity and gender expression. So essentially, the trans panic defense is also not going to be available. Only one of the bills, the first bill, applies to nonviolent sexual advances specifically. So the bill, New York A02707, so that middle column there, actually specifically says that if the victim has a nonviolent sexual advance, even if it's a same-sex advance, that is not a good enough reasonable reason for somebody to kill them. The other bill, 2400, does not address nonviolent sexual advances in its language. And then finally, with regard to the bills covering, discovery, knowledge, and/or disclosure of somebody's sexual orientation, gender identity, or gender expression, both bills cover it at least in part. So the first bill touches on the discovery only. So if somebody were to discover a person's sexual orientation or trans status, that would not be a reason to justify murdering them. That would not trigger the extreme emotional disturbance defense. But for the other bill, it would be a little broader. So that would cover, discovering somebody's sexual orientation, gender identity, and expression, or learning about it, knowledge of it, knowing that that's true, or when somebody discloses it to them. So it's just a little bit broader language, and it covers the language that is reflected in the model that came out of the Williams Institute as well. So as you can see, they both cover the gay and trans panic defenses in slightly different ways. In some ways, it seems a little broader and more encompassing than others, but sort of in equal and opposite ways. Before I compare these bills to other states, do we have any questions?
We don't have any questions just yet, which I'm sure means that the presentation has been thorough so far. Actually, we just got one. Sorry, I spoke too soon. We just got one.
Okay.
Does the Williams Institute language cover nonviolent sexual advances?
Yes.
Okay.
Yes, it does. And we're actually going to look, the next chart I'm going to show you, which is, everything is a little smaller because there's a lot more on there, but we'll talk about it. You'll see that the model covers everything. So, yeah.
Awesome. And then just as a reminder, for folks that want to ask a question, if you hover your mouse at the bottom of the screen, a little chat box should pop up where you can write it in. So just wanted to clarify that.
Great, thank you. So now we've seen how these two compare to each other, and we can come back to it if we need to look at them more closely, but let's see how they stack up against other states and against the model. So in this chart, a little bit bigger, so apologies, there's a lot of information to pack in there. But you can see our state's bills lined up in the same way on the very far right. So we have the two bills there. And now we see how they stack up against the model that came out of the Williams Institute, California's law, Illinois, and Rhode Island, okay? So across the top, we see, again, restricting defense and provocation. All of the laws and all of the bills, including the two that are proposed in New York, would touch on provocation, would touch on that extreme emotional defense or heat of passion. That's what it's talking about. When something so outrageous provokes you into a blind rage and fury that you lose track of your actions and you just act in a violent way. That's what they're talking about with defensive provocation. So all of them across the board cover that. Now, in the model language put out by the Williams Institute, it also covers instances of what it calls diminished capacity, which could deal with mental illness as well as potentially possibly substance use, but typically it has to do with mental illness. And then also instances of self-defense. So the model language actually covers all three of these sort of possible affirmative defenses that somebody could try to raise. And so far, across the states, Rhode Island is the only state that has taken on that language verbatim. So California, Illinois, and our two bills in New York don't touch on diminished capacity, mental illness, or self-defense as part of the language of the laws or the bills. So that's something to think about and keep aware of. Across the board, all of them cover sexual orientation. So the model covers that. And even Illinois covers it. Even though they don't cover gender identity and expression, they do have sexual orientation. And all of that is covered in our bills as well. And as you can see on the next row down, Illinois is the only state so far that did not go out of its way to include sex or gender identity or gender expression. But that language is covered in both bills that are being proposed in New York and aligns with what the model includes as well by the Williams Institute. So the next two rows, the last two rows at the bottom, we're looking across, we see how the New York bills stack up against what the model says and also what these other three states have included in their laws, which are dealing with nonviolent sexual advances. So again, when we're talking about that, we're talking about, we have the one individual who said that he woke up and had a sword pointed at him and was being told that he had to have same-sex interactions, or he would be cut by a sword, allegedly. That would be a violent sexual advance if it were true. But nonviolent sexual advances are flirtations, are coming on to people in bars or in public transportation, or just talking to another person or looking at another person, and that being interpreted as a sexual advance by somebody who, for whatever reason is interpreting it as that and feels threatened by it. So the idea is that for some reason, nonviolent sexual advances by people of the same sex are heightened to this place of being violent or extreme in a way that nonviolent sexual advances by people of the opposite sex are not. And so there's this unfair application of what is considered violent just by virtue of it being perceived as a sexual advance across the board. So the model covers nonviolent sexual advances. Most of the states do too. The first of our two bills, the one that was proposed by Daniel O'Donnell, also includes and talks about nonviolent sexual advances. But the second bill, the one proposed by Assemblyperson Barnwell, does not. So there's no mention of nonviolent sexual advances at all in the second bill. In the final sort of criteria and consideration, we're looking at the discovery, knowledge, and or disclosure of somebody's sexual orientation, gender identity, and gender expression. And across the board, everybody includes that information except for the first of the two New York bills that are currently being proposed, the one that is proposed by Assemblyperson O'Donnell. And that one, in his bill, in the bill that he proposed, only talks about the discovery of somebody's sexual orientation or gender identity. It doesn't mirror the language around knowledge and or disclosure. So which is to say that all of these are very similar. There's a lot of similarities across the board. There are a lot of ways in which they all are mostly as broad and as all-encompassing as each other. But it's helpful, I think, to see the ways in which our two bills in New York State sort of stack up against one another, right? So that being said, I guess now would be a good time actually to see if there are any questions about this.
No additional questions as of yet.
Okay, great, thank you. Okay, so that being said, I think some final takeaways, which I'm gonna just say instead of looking at the slide, I'm gonna pull it back to the two bills that we have currently in New York. The final takeaways, I think, are this, and then I'm gonna hand it back over to Trevon to wrap us up, but you know, no matter what, banning the gay and trans panic defense in New York is a win. It's a literal win for our community because it means that criminal defendants, either, you know, whether they're up for second-degree murder or depending on what we end up with as our final law, if we get this, second-degree murder, aggravated murder, or first-degree murder, regardless, would not be able to use their homophobia and transphobia as a shield against culpability for their actions. So when somebody hurts a member of our community, they can't turn it around and say that they did it for a good reason. It is never a good reason. And so it's literally a good thing when when defendants are not able to use falsities about our community against us after they've harmed us in a way to try to get off the hook. It's also a symbolic win because it will further establish and reiterate and emphasize and amplify our state's strong policy in favor of LGBTQ lives and experiences, and recognizing that a justice system that permits that sort of defense to be raised is not a justice system at all. So doing it no matter what, I think, is a good thing. It's heading in the right direction. Also, another takeaway is that, in my opinion, neither proposed bill is perfect, right? But either will cover most circumstances where this sort of defense might be raised in a way that will be effective for most situations. Is it possible that somebody would raise this defense if they were charged with aggravated murder and first-degree murder? Sure. The statute, the law, allows a person who's charged with those crimes to raise an extreme emotional disturbance defense. And as long as they are able to raise that defense for a whole variety of different reasons that they might come up with, one of those reasons could be a gay panic or trans panic defense of some kind. Is it likely to happen? Probably not. A lot of the situations where somebody is charged or convicted of aggravated murder or first-degree murder are because the circumstances surrounding the thing that they did are pretty egregious and sometimes involve sort of other things happening, such as like committing other felonies like burglaries or robberies, or trying to target judges or trying to target police officers, or essentially going on a killing spree of some kind. So all of these things, reduce the chances of this sort of thing being raised. But as long as the extreme emotional disturbance defense is available to those crimes, the window will always remain open for somebody to use it and apply it in a way that is harmful to gay and trans people by wielding sexual orientation and gender identity and expression as a shield for liability. So would a bill that covers all of the circumstances where it might arise be more effective? Probably. Is it going to come up and somebody going to use the loophole if we don't close the loophole on all three of the charges? It's hard to say. There's the argument that we might always come back for it later if it does happen, right? Let's get second-degree murder now, since that's the charge that hate crimes laws apply to also. Let's just get that done. Let's make sure that that is sealed tight and that nobody can use the gay or trans panic defense on those charges. And then if somebody does further down the line, we can come back to it. Sure. It's always possible that we'll never get around to coming back to it. That's something that happens in legislative policy advocacy. So maybe we should do it thoroughly this time around, maybe. But also the bill that covers all three charges is not as broad and as thorough in other ways as the other bill with regard to, naming nonviolent sexual advance as something that can't be used. And the one that does name that also isn't quite as thorough about the kind of, about knowledge and disclosure. So in my opinion, the ideal scenario would be a combination of the two. But if we ended up with either one, I think we'd come out ahead. And with that, I would say that the final takeaway is that you can get involved in this process in one of many ways. And for that, I'm actually going to hand it over to Siobhan to talk about the different ways that you can do that. So, thanks to take it away.
Thanks, Milo. A quick question that we had before I transition is around the possibility of amendments being added to either bill to improve, to also apply to nonviolent sexual advances, whether you thought that might be a possibility.
I mean, I think it's always a possibility where things are in the process at this point. Amendments are totally still on the table. Amendments could be made, friendly amendments could be made on the floor, they could be made in committee. The people who are sponsoring and co-sponsoring either bill can work together to create a more unified bill that is closer to the model that UCLA put out, the Williams Institute, or a variety of different things. So yes, amendments could still very much be made. There hasn't been any significant movement on either of these things to get them in front of the governor yet, and so it's definitely not too late for changes to occur. But they won't happen by accident, so you have to advocate for them.
Thank you. I just wanted to add that, as Milo mentioned, passing any law in New York State that bans the use of the gay trans panic defense is ultimately a significant win for the community, and the center is supportive of that. With that, we're also mindful that one of the bills mentioned, which is the bill in the Assembly that's sponsored by Assemblymember Brian Barnwell, has gotten significantly more traction since it's been introduced. Our hope is that our advocacy efforts can build enough support and awareness to get either bill passed, but we are working to mobilize community around that particular bill, given where things are right now. So to mobilize community in support of the bill, the center launched a community petition. We currently have over 1,000 signatures and would love to see more folks sign on, because our goal is to deliver these names to lawmakers before the end of the session in June. So you can find the petition at gaycenter.org/demand justice. And if you've already signed the petition, please share the petition with community members in your network. The more folks that have added their names, the stronger the case is that community wants to see changes happen in the legislative session. And then lastly, we've created a toolkit so folks are equipped with the language to contact their lawmakers, and that lives on our website. So it includes talking points about what the legislation is and what banning the gay trans panic defense would do. So feel free to utilize any of these tools, and you can find them at gaycenter.org/advocacy. You can also join our mobile advocacy network. So if you take 2 seconds to grab your cell phone and text the word RiseOut to the number 69866, you'll automatically start receiving alerts on ways that you can take action for LGBTQ rights whenever there's an opportunity to. And we want to make sure that our community is informed and engaged in real time. And so joining a mobile advocacy network is one way to ensure that you're not missing out. If you're already signed up, you can also share that number with a few friends to make sure that they are a part of the fight too. And then I just wanted to take this moment to say that thank you all for joining today's webinar. A recording of the webinar will be available on our website in a few days, and I will also follow up with an email. If you do think of any questions, feel free to contact myself, or Milo left his contact information at the beginning. But if you have any other thoughts or questions that you want to sort of go over that the presentation did not cover, always feel free to reach out. And again, thank you, Milo, for taking the time to give us a very detailed and robust understanding of the legislation and the law.
Oh, it's always my pleasure. Thank you so much for having me. Are there any questions before we jump